In this lecture, we would like to discuss another principle that was developed out of the report of Brundtland Commission and those international documents that developed out of the Stockholm Environment Summit, also from the 8th Summit of Rio de Janeiro of Brazil. So now we'll discuss the very introduction regarding precautionary principle that developed out of those international documents resulted out of the Stockholm Conference, Environment Conference in 1972, and the Rio de Janeiro Earth Summit Conference of 1992, and the recommendation of the Brundtland Commission of 1987. So, the precautionary principle is accepted as a fundamental tool to promote sustainable development and has an important function at both international and national levels. It provides for action to avoid risks of serious or irreversible harm to the environment or human health in the absence of scientific certainty about that harm, and offers the authority to take public policy decisions covering environmental protection in the face of uncertainty. Where there is no uncertainty in this calculation of risks, there is no justification for the employment of the precautionary principle. The scientific uncertainty is at the core of the precautionary principle. However, the international application of the precautionary principle is an open ended issue. Some believe that its use helps make better health and environmental decisions, whereas others think that employing the precautionary principle is inconclusive due to the difficulty in achieving a consensus that reflects appropriate responses to manage risks, benefits, and cost. Excessive description tends to unpredictable and inconsistent environmental decisions distorts regulatory priorities, stifles technological innovation, and reverses the burden of proof, reflecting uncertainty between science based governance and the over or under application of the precautionary principle. In India, pollution produces complex environmental issues involving scientific uncertainty and imprecise health risks. This pollution matters are influenced by incomplete information, inconclusive evidence, ambiguous values, and public controversy. For example, the study identifies how such cases differ in the level and type of scientific uncertainty. The study highlights the debate regarding particulate matters and concerns the health impact of different particles The underlying causal mechanism of these health impacts and the nature of exposure response relationship for various health endpoints. It may result in varying judicial responses. This uncertainty creates governance challenges for regulatory and adjudicatory decision makers concerning health, well being, and the environment. And now we'll discuss that certain principles, and such as the Principle 6 of Stockholm Declaration of 1972 and Principle 15 of Rio Declaration of 1992 clearly mention about the precautionary principle. And now, in that connection, we would like to discuss the judicial application of these principles. That precautionary principle in case of India. So, the role of Supreme Court in India in recognizing the precautionary principle as an essential feature of sustainable development and a part of customary international law, promote its application from constitutional mandates, namely Article 21, Article 48A, and Article 51A, Clause G. In 1996, Justice Kuldeep Singh in Vellore Citizen Welfare Forum vs. Union of India declared that the principle involves three conditions. One is state government and statutory authorities must anticipate, prevent, and attack the causes of environmental degradation. And the very second condition that he mentioned in the principle where there are threats of serious irreversible damages, lack of scientific certainty should not be used as a reason for postponing measures to prevent environmental degradation. And the third conditions he mentioned under this precautionary principle is the onus of proof is on the actor or developer of industrialists to show the action are environmentally benign. Additionally, the Specialized Environmental Tribunal, National Green Tribunal, is a creation of a statute. Its adjudication powers and procedures are constructed and applied according to the language of the National Green Tribunal Act of 2010. The National Green Tribunal interprets and applies the precautionary principle as mandated by Section 20 of the National Green Tribunal Act 2010. The applicability of the precautionary principle is a statutory demand to the tribunal while deciding or setting disputes arising out of substantial questions relating to environment. Thus, any violation of or even an apprehended violation of this principle would be actionable by any person before the tribunal in action in the facts and circumstances of a given case could itself be a violation of the Precautionary principle. Thus, the precautionary principle in India mandates well-judged uses in favor of observing, preventing, and mitigating potential threat due to environmental pollution. Indeed, modern risk factors have become more complex for reaching and adversely affect public health and environment. The principle is employed as a tool within Indian environmental governance to promote better health and environmental decisions. However, the principle is both controversial and difficult to apply due to its inconsistency and misapplication of legal standards of proof. And now we'll discuss the very methods and approaches applied by the decision makers and by the influencer. Mixed methods and purposive sampling approach were preferred to gather empirical data to have a broader perspective of the research in question. Pilot fieldwork data were collected from 35 key environmental actors involved to varying degrees in the National Green Tribunal in 2019. Key environmental actors were the decision makers such as the National Green Tribunal, the judiciary, and the scientists and the influencers or the pollution control board members, environmental lawyers, also those environmental activists to assist them in environmental matters as amicus curiae or qualified external experts on the tribunal appointed committees for fact finding and scientific evaluation processes. The data were specialized, collected, appointed committees of fact finding and through questionnaires, interviews, semi structured and open ended, and the 5 live interactive specialist workshops. All interviews were recorded and subsequently transcribed. Individual permission to use all recorded material that was obtained. The workshops also focused on knowledge, awareness, and capacity building by interactions between key actors to improve understanding of complex scientific uncertainties, economic and environmental challenges, and corresponding legal responses in an adaptive manner. And now we'll discuss certain important landmark judgments that relate to the very precautionary principle. And in regards to that, we would like to discuss the first important leading case that is decided in 2016, Bardhaman Kaushik versus Union of India, where the legal standard of beyond reasonable doubt is assigned level 9 as the contributory sources of air pollution, such as vehicles, construction activities, burning of municipal solid waste, and agricultural residue, dust, and roads. industrial and power house emissions including fly ash and emission from hot mix plants and stone crosses in Delhi were firmly identified. The convincing data showed that the ambient air quality was severe and adversely and hazardously affected the public health and persons of all generations without exception. Accordingly, the National Green Tribunal ordered precautionary measures, including banning 15 years old vehicles or older, closure of stone crossing units, implementing dust management plants, installing air purifiers, no burning of waste, and preference to the use of public transport systems. And now we'll discuss another important ruling of Supreme Court in another leading case, that is Satara Municipal Corporation versus Ministry of Environment and Forest in 2017. The standard of clear showing assigns it level 7 as it is very probable that the new and unforeseen conditions will cause serious harm or damage. The case involved the proposed reconstruction of a dam near the World Heritage Site of the Cusp Plateau. The proposed new reconstruction activity would adversely affect the sensitive ecology of the Cusp Plateau, including ecological reaches and habitats supporting various plant communities and high numbers of plant and animal species. The National Green Tribunal applied the precautionary principle by requiring formulation of environmental safeguards, measures, and management plans prior to the execution of the proposed project. And now we'll discuss another important ruling, that is Sant Aklonar versus Indian Oil Corporation, and it was a case of 2014. The next important proof in this case was substantial and credible evidence, as being level 6 is associated with this case. The National Green Tribunal considered the potential sources of groundwater pollution either by the pressure of oil deposits or industries in the surrounding areas. Applying the principle of proximity, the National Green Tribunal was of the opinion, based on available data analysis reports and documents, that a strong correlation existed between the types of contamination of the groundwater and oil storage depots. The National Green Tribunal, while applying the precautionary principle, ordered regular monitoring of the groundwater, including necessary treatment and disposal. And now we'll discuss another important ruling relating to the case Indian Council for Legal Action versus Ministry of Environment and Forest, where the very standard of reasonable, articulable grounds of suspicion is the least stringent standard with the lowest level of optimistic evidence. This is level 2 and is applied to the Indian Council for Legal Action versus Ministry of Environment and Forest, a case to determine whether HFC C23 emission for say are a pollutant. The HFC 23 forms part of greenhouse gases that have an impact on depletion of ozone layer and global warming, but there are concerns about their extent and degree. Accordingly, the National Green Tribunal directed the regulatory and expert bodies to conduct a comprehensive database study on chlorofluorocarbons, which causes and its impact on global warming. And now we'll discuss another important ruling, that is Rance enlightening humanity versus Ministry of Environment and Forest, where the standard of preponderance of evidence level 5 is assigned the location of an plant near human habitation was a contested site based on a few maps and photographs as convincing evidence. The National Green Tribunal found that the plant was bound to have hazardous effects on the health of the residents in the area, some of them being adjacent to the site, the contested site in which the plant was located was more likely and bound to cause groundwater pollution, which was relatively at a higher level through leaching. So, accordingly, the National Green Tribunal applied the precautionary principle and ordered the closure of the plant and granted a permanent prohibitory injunction. And now we'll discuss another important judgment, and that is relating to Vellore Citizen Welfare Forum versus Union of India in 1996. The Supreme Court was convinced beyond a reasonable doubt, therefore, Label 9, that leather tanneries operating in Tamil Nadu destroyed the ecology, degraded the environment, and posed a health hazard. The technical reports evidence the untreated effluents from nearly 900 industries polluted groundwater, contaminated agricultural lands, and exposed the residents to serious diseases. Accordingly, the Supreme Court applied the precautionary principle and directed the closure of tanneries, prohibition and restrictions on the location of industries, and installation of treatment effluent plants before the reoperation of industries. And now we'll discuss another two major important cases relating to precautionary principle, MC Mehta versus Union of India in 1997, and both of these two cases, one is relating to groundwater and the second one is relating to lakes, show the standard of clear and convincing evidence. Level 8 is applied in MC Mehta versus Union of India relating to groundwater, dealing with groundwater depletion's evidence supported by technical reports convinced the court that there was a gradual depletion and of groundwater levels, dwindling water resources, deterioration of groundwater and surface quality, and a haphazard use of land. To assess the complex issues in water resource management, the Supreme Court directed the constitution of a water authority to operationalize the precautionary principle. The water authority was expected to plan, develop, and implement research on sustainable water resource management. And in the second case, that is relating to lake, and that is also filed by the petitioner M.C. Mehta. The standard of clear showing is applied at level 7. The Supreme Court, while applying the precautionary principle, placed restrictions on the proposed new construction in the areas outside the green belt of the Badkhal and Suraskund lakes. Based on expert opinion, the new proposed large-scale construction near the lakes was bound to cause adverse impact on the local ecology. The proposed construction activity may disturb the rainwater drains, thereby impacting on the water levels and water quality of the water bodies and disturbance to the aquifers and hydrology in the area. And now we'll discuss another important ruling of relating to Andhra Pradesh Pollution Control Board versus Professor M.B. Naidu, retired in 2001. So, the standard of reasonable, substantial, and credible evidence, which is level 6. The Supreme Court consider whether the establishment of chemical industries carries with it the imminent danger of chemicals or chemical effluents polluting the waters of Himayat and Osman Sagar lakes, based on exhaustive scientific evidence provided by expert organizations. The Supreme Court applied the reasonable person test and concluded that there was every likelihood of the industry affecting the sensitive catchment area of the lakes. Accordingly, the court applied the precautionary principle and directed that the regulatory agencies should not permit any polluting industries within the radius of 10 kilometers of the lakes. And now we'll discuss the last most important judgment on the application of precautionary principle is the Democratic Youth Federation versus Union of India in 2011. So the very standard of reasonable, articulable grounds for suspicion is applied to, in this case, as label 2, considering the ill effects of indosuflan on human beings and the environment. The differing reports presented to the court regarding the usages and of endosulfan and its impact on human health and the environment led to the application of precautionary principle. Consequently, the court ordered the interim ban on the production, sale, and use of Indo-Softland and an undertaking of a detailed scientific study on Indo-Softland. So, after discussing all the relevant landmark judgments which directly applied the very precautionary principle which resulted out of Principle 6 of the Stockholm Environmental Declaration of 1972 and the Principle 15 of the Rio de Janeiro at Summit Declaration of 1992. So now we have to conclude the very lecture on precautionary principle. So, as regarding the court's rooms cases are invariably decided by factual evidence supported by witness and experts. The evidence is mediated and presented by advocates speaking the language of law to the judiciary. However, in environmental cases, the role and status of science and technical expertise are increasingly important factors in decision making by the court. Academic literature recognizes that current different understanding of the precautionary principle in formal scientific levels of certainty or uncertainty and legal standards of proof may introduce subjectivity into the judgments. This may result in vague and the formulations over and under reaction to significant or insignificant risks and opposes technological innovation based on unproven institution. So we would like to highlight two principal issues in environmental decision making by the Indian judiciary. The first examines the meaning, appreciation, and application of the precautionary principle by key environmental actors who are regularly involved in the presentation or resolution of environmental issues in the National Green Tribunal. The unique pilot survey establishes that the range of key environmental actors differ in their definitions and usages of this principle. There exists limited common understanding between decision makers and influencers about the normative aspects of the principle and related scientific uncertainty. And the second issue that we focus on scientific uncertainty, the legal standard of proof and the impact on the precautionary principle. So the findings presented in our lecture encourage next step thinking in India's environmental governance. There is a need to develop a framework of guidelines that recognizes the normative aspects and legal standard of proof for scientific uncertainty in the application of the precautionary principle, adopting from foreign regulatory guidelines and developing a scientifically legal lexicon that expresses different levels of scientific uncertainty in a legal language. The framework would provide a roadmap regarding the usages of the precautionary principle. Such a framework would assist the Janus first precautionary principle to become a consistent, effective, accountable, and transparent tool. This would enable decision makers to promote the environmental rule of law and further India's commitment towards sustainable development goals as projected by the World Environment Conference of Stockholm in 1972 and also of the Earth Summit of Rio de Janeiro of Brazil in 1992. So we have concluded our important lecture on the very principle of precautionary principle and its very application in India as through the National Green Tribunal and also why the decision makers and the influencers and overall its direct implication due to the landmark judgments delivered by the apex court or the Supreme Court of India.